Your Honour, if it pleases the Court, my name is Voogt, V-O-O-G-T, initials L-H. I'm appearing here today, Your Honour, acting on behalf of my client, a Mr. Darren Selders. Your Honour, my client was arrested with 9 charges of burglary and stealing pursuant to sections 390 and 419 of the Criminal Code. It is the view of the Defence Counsel that there is evidential arguments to exclude the current evidence with regard to the charges that my client is facing. If it pleases the Court, these submissions will be made so for an application for evidence dismissal under Section 130 of the Evidence Act and 519AA of the Criminal Code. Your Honour, Darren Selders is a 14-year-old Torres Strait Islander boy living in Townsville when he was first taken into police custody under suspicion for the unlawful entry of a property on the 20th of March of 2019. This then led to my client being arrested and charged with additional burglary and stealing charges for the other recent residential break-ins. Your Honour, the young age and the cultural background of my client must be taken into consideration when looking at the evidential procedures and the questioning of these circumstances. These things, Your Honour, of his age and his cultural background significantly increases his vulnerability as a witness, which must under the law be protected pursuant to Section 9E of the Evidence Act. Your Honour, it is the view of the Council that the arresting officers on the 20th of March did not take these pertinent conditions into account when conducting the questioning when first arresting Mr. Selders, nor during the formal interview at the police station. The Defence Counsel requests that the Court considers that the admissions made by Mr. Selders during these interviews and questionings to be excluded from the evidence. With the leave of the Court, I will now go through the Defence Counsel's main arguments as to why evidence should be dismissed. Your Honour, Darren Selders is 14 years old, which, according to Section 421 of the Police Powers and Responsibility Act of 2000, hereafter referred to as the PPRA with the leave of the Court, make him a child for all intents and purposes. Thus, he must be treated with the requirements as outlined in the statute in order to protect his vulnerabilities. As my client is a child, the arresting officers were prohibited under Section 421, subsection 2, to question my client without a support person present that Mr. Selders chose himself. Your Honour, at no point was Mr. Selders offered and afforded the opportunity to contact his own support person at the time of the initial arrest when the officers first reasonably suspected Mr. Selders to be a child. There is no evidence that these on-duty officers had at any point made as well any reasonable efforts to contact any parents of Mr. Selders, nor wait for any other support persons to arrive at the police station, nor the scene of the arrest. Your Honour, the social worker, a Ms. Wendy, was contacted by the officers, which then acted as his support person only during the formal interview. Your Honour, this doesn't mean that she was the contacted person that Mr. Selders chose himself to be present during any of the questioning. Your Honour, my client was taken into police custody, then driven around in the neighbourhood and questioned by the officers about other recent break-ins in the area. My client was questioned without a parent or chosen support person present. This conduct of the arresting officers is in direct violation of my client's right to have a support person present during all questioning as pursuant to Section 421 of the PPRA. As a result, Your Honour, no support person was questioned, thus rendering the evidence obtained in all aspects arguably admissible. As per Section 21 of the Evidence Act, the cultural background of a witness must be taken into consideration, as this background of a witness is more than likely to affect how they perceive others, understand questions, and respond to these questions. Your Honour, Section 420 of the PPRA specifies that when questioning an adult Torres Strait Islander, it requires the officers to inform legal aid as well as also a support person prior to commencing any questioning. This section applies exclusively to adults. However, it is the view of the Council that the cultural background of my client should not be discounted. It is the opinion of the Council that this cultural background carries just as much significance as his age, as it still significantly increases Mr. Selders' vulnerabilities. In the submitted evidence in question, there is an indication that Mr. Selders consistently avoided eye contact and does not answer any questions beyond responding with single statements and mainly agreeing with what's being asked of him. Your Honour, this behaviour is a cultural phenomenon used to define relationship between those talking, and it is a clear indication then of gratuitous concurrence in an attempt to implicate the police officers. This cultural and linguistic behaviour requires the officers to adopt their approach to questioning my client, but this was not done at any point in the interviews. In light of this breach, it is the view of the Defence Counsel that the evidence obtained in questioning did not take reasonable steps to ensure that my client is a poor person to aid him in responding to questions and making sure he understands of what is being asked of him. In summation, Your Honour, the Defence Counsel seeks for the Court to consider exercising the discretion as per Bunnings and Cross to exclude the evidence presented from the formal interview at the police station, as well as questioning that took place in the police car. The method and the conduct of the police officers in obtaining this evidence has been a clear breach of provisions under the PPRA as well as the Evidence Act, which was discussed before. As I alluded to before, Your Honour, the Council argues that the lack of a support person chosen by my client being present at any stage of the questioning warrants the exclusion of all submitted evidence under the Bunnings and Cross test that specifically looks at the fourth and the fifth factors. Your Honour, in conclusion and in closing, it is left to the Court to decide and administer the discretion to decide whether the evidence is to be excluded. Your Honour, if there are no further questions, I'd like to conclude my submissions for this day. Thank you.